Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. We meet every other Thursday between 12:30 and 1:30. You can join by calling 202-800-8394, 202-800-8394. But please post your questions in our forums ahead of time for an area reserved for this, and you'll see all these links, etc., from our website as well as from our social media sites. I have a lot of questions to cover, will not have time for new questions. So let us go over the frequently asked questions first. We will cover substantial ground on the NTA policy announced by Trump misadministration. I'm sure I can't call them administration. They have outdone themselves in, again, trying to make things as difficult as they can for immigrants, legal as well as undocumented. So let's begin by going over the frequently asked questions one by one first. One of our community members wanted to know, can I get a promotion or change job description while green card is pending? And the answer is, if we are speaking of a green card filed through PERM, the answer is that's complicated, because any substantial change in the job requires you to refile the green card unless you have the intention to go back to the old job when you get the green card. So let me give you an example. Let's say you begin your labor certification PERM application through a job like systems analyst, and 6 years into the process, your employer wants to give you a promotion and you want to accept it as a project leader. You can take this promotion using the following three methods. Three methods for a promotion while the green card is pending. One is to take the project manager's job with the intention to come back to being a systems analyst when your green card is approved. So in other words, you'll take a demotion when you get your green card. Second method is to make sure that the jobs, even though titles are different, are not substantially different in job description. Third method is the one that we do normally, which is process the pending case of systems analyst to I-140, then file another green card, a PERM application for the new job of project manager. The PERM will be processed all over again, I-140 will be processed all over again, but the priority date of the old case will be inherited. So now, effectively, you have a PERM application and an I-140 approved for project leader, but you have the priority date of the old case of systems analyst. Bear in mind that a priority date is not conferred or earned until your PERM is approved and your I-140 is approved. Only then the priority date becomes yours to keep. Okay. From a planning perspective, I recommend to people to project their mind. If you're India born, 7, 8, 9 years, India, China, Philippines, Mexico, all the backed up countries where the dates are way backed up, you want to probably plan for a job in the future, projecting your mind 7, 8 years. So if somebody comes to me and says, I'm going to be a systems analyst, when we talk with them, we would like to ask them, is this what you're going to be in 7 or 8 years? Sometimes that's easy to predict and the employer has a clear path in mind, and sometimes it is not that easy. Nevertheless, that's a good thing to think about from a planning perspective. One point at which you can change jobs whether job descriptions, job titles, or even employers, is when your I-140 is approved and your 485 has been pending 180 days. That's the AC-21 portability. Most people already know about this. So the question is, for this gentleman or lady who's posted the question through Deepa, our editing team member, this person says, my company is telling me I can't get promotion till my green card is approved. Now this is a slightly different situation. No, actually, I guess it is the same. This is what I had just discussed, and I think I've covered it all. So in any of those 3-4 circumstances that we discussed, you could change your job description, job title, antecedents, etc. Folks, I will not have time for new questions, only for posted questions. If you have a follow-up question on what I just discussed, press *5. No new questions, only follow-up, please. Any follow-up questions on this issue that I discussed? Okay, I have one. And this one is from Illinois. Okay, Illinois, go ahead, please. I can hear you.
Yeah, so I think you mentioned something about 485 pending for 6 months under, I guess, AC-21 clause.
Right.
So I just want clarification, I'm in that situation. So I'm with my second employer, not the one who filed my, 140.
Right.
And, the same boat, 9 years going. And now they've offered me a promotion. And I don't know what my options are at this point.
No. Absolutely go for it. We have processed, if not thousands, hundreds of cases under AC-21 portability. We have never had any problems. If your lawyers work with you and they plan for it properly, review the job descriptions, having a promotion or a change in green card, change in employer, change in job location, all of this are available as options under AC-21 once your 485 is pending 180 days. So go for it. It's a good option.
But then do I have to, you are saying that I have to work with not just with my employer who probably doesn't know all these complications. So I have to involve my attorney so they can file my AC-21?
Not at all. I was assuming that you are working in the same company on a promotion. But if you are changing employers, you are well within your rights to change lawyers. Your lawyers can advise you on they can compare the job. This is what we do typically. When we get retained for something like this, we review the job descriptions, both from the labor certification and the proposed job description. Make sure they are similar, because the law requires same or similar jobs. As long as we feel reasonably comfortable they are similar, you can go for it.
Yeah, so that's good to know. I'm in the same company, meaning I changed the company a few years back on AC-21 and, it's all good. And now they offered me a promotion, which I actually accepted. It's the same or similar job description, one might say. It's just, the next level. So I'm still in the same line and everything.
Absolutely. This looks like a reasonably easy case to process in terms of, I bite my tongue when I say easy. I mean legally easy. I don't know how procedurally easy it will be. But the way it works is, you see, first of all, there is no limit to how many times you can do an AC-21 portability. So let's say you took a job after 180 days with IBM. Then 15 days later, they offered you a much higher level job in the same trajectory. You can take that. And then Sun Microsystems came at you and said, look, come work for us. You can do another AC-21, and then you can go work for Microsoft. AC-21s has no limit. You can change as many jobs as you like.
Right. Okay, now I think in this case, I don't think even AC-21 will apply because I'm with the same company who has filed AC-21 and I've been working for 5 years, and now they offered me promotion in the same line, same trajectory.
Well, it still will be an AC-21 portability, because if it is a substantial, this is where the law comes in. So the legal people need to get together with your technical people to determine whether or not this job is substantially dissimilar from the applied job. So it's a very odd situation where on the one hand, we are looking at whether the job is substantially dissimilar that it requires an AC-21 filing, and then in AC-21 filing we say it's the same or similar job. Okay, it's a very odd situation, but we have to, that's the way the law is set up. We do both these determinations, and it's a relatively straightforward process.
Right. No, thank you. I mean, I appreciate it, and believe me, I consider all options, including starting a new, green card. But unfortunately, or fortunately, I think my priority date seems to be very close, like 2 months now. So I don't think I'll have enough time to, start a new firm either.
I don't see the need for a new green card for AC-21 cases. Just make sure that your AC-21 jobs are sufficiently similar, and you're good to go.
Right.
Okay.
Okay. Thank you very much.
Oh, you're welcome. Okay, so there are no follow-up questions. Let's go on to the next frequently asked question. Once again, I'm reminding people who are logging in, I won't have time for new questions, folks. There's a lot going on here. We have to cover the NTA part, which might take a long time. Now, Mr. Dubey or Ms. Dubey, Praveen could be a Ms., I guess, but this looks like Mr. Dubey, wants to know how does this process of H-1B revocation during visa and reaffirmation works. So, and he had some questions about what are the options available if this happens. Is there any way to speed up the process? What are the chances of petition getting reaffirmed? So, to give you a quick overview of what happens in these types of cases. So let's say you've got your H-1B approval, but you have traveled outside USA and you need a new visa. So what do? You go to the US consulate for visa stamping. They put you in administrative processing and discover something which often is unjustified, frankly, and sometimes can be justified. Gives them some reason to send the case back to the USCIS saying, hey guys, this case needs to be revoked. And that can take a few months, 4, 5, 6 months. Then USCIS will issue a notice of intent to revoke, which will be sent to your lawyers as well as to your employer that says we found out this information through the consulate. It looks like this case needs to be revoked. You have 33 days to respond and tell us why we shouldn't revoke it. Once the employer responds to it, if USCIS finds out that the case is really approvable and the consulate is mistaken, they reaffirm the case and send it back to the consulate. This whole thing can take months upon months upon months, up to a year easy, hopefully closer to 6 months, but there is really no guarantee. I know cases that have taken almost a year to go through this entire process and be reaffirmed and sent back to the consulate. So what are the options available? You can, of course, always file another H1. If this was not a quota H1 and there's no fraud, etc. involved, you can file another H1 through another employer or with the same company. It can always be done. What are the chances of the petition getting reaffirmed? A lot of the cases that we have seen, they have been reaffirmed and sent back to the consulate. I don't think I can give you a percentage because it's like asking somebody what are the chances of, I don't have a good example. I was going to say something and then realized that was kind of foolish. So I track back. It's just impossible to predict what the chances of reaffirmation are because we don't know the case. Each case is different. So I think that covers these issues. If you have any follow-up question on this, press *5. No new questions, please. Only follow-up questions. Okay. So this is another issue that comes up quite frequently. And this particular issue applies to everyone, whether it is H4, L2, L1, H1. So the question is, once I enter USA on parole, such as advanced parole given on I-485, and I want to convert back to H4, what do I do? You cannot really do a change of status because parole is not really status. It is just authorized stay, which is legal but not full status. And I have a fairly lengthy frequently asked question on the difference between status, unlawful presence, authorized period of stay, all these items. So if you look at the frequently asked questions on immigration.com, This issue has been discussed several times. So basically, if you want to convert back to H1, let me strike that, make that H4, because H4 does not require any prior approval from the USCIS. Like for H1L1, you need approval of the H1L1 petition before you can go out, get it stamped. But H4 and L2 people can just get their visa stamped based upon the H1 or L1 approval. So you can just take the spouse's H1 approval and go outside USA, get your visa stamped and come back. When you enter using your H4 visa, you are back on being on H4 instead of being on parole. And if the I-140, 485, etc. are still pending, you can of course keep extending your advanced parole 6 months. I think you can, yeah, you can apply 6 months ahead of time before the expiration of the parole. I trust that answers your questions, Hital. *5 if you have a follow-up question on this. *5. Once again, some people are just logging in. No new questions today, just the posted questions, please. Okay, let's go on to, this is also another very important topic, Section 245K protection. This is a very important protection given to employment-based applicants and their dependents when they apply for adjustment of status. What it says is that under Section 245K, USCIS will forgive your being out of status or having worked without authorization for up to 180 days from the date of your last entry into the US immediately before you filed the 485. Let me give you an example. And this is a, look, I'm not going to be able to read your entire fact pattern. It's a little too long and too involved, but I think I can give you, I have a general sense of what happened to you. So I can give you a generic answer, see how it applies to your case. So in this case, I think what happened was there was some unauthorized employment in 2009, but then they left the United States for a few weeks, months. Even if they had left for a day, their 245K clock would be reset. So it really is not a problem. When you came back to USA in 2013, all your prior sins were washed away. That's what 245K says. We will only consider your sins from the date of your most recent entry before you filed the 485. Of course, you must not have unlawful presence for more than 180 days. As long as there is violation of status, chances are 9 out of 10 you don't have any problem because of 245K that allows you to wash away your sins each time you come back into the USA. So taking your example, let's say in 2009 you had a year of unauthorized employment, whether it was deliberate or mistaken, it doesn't really matter. Technically, if you filed a 485, then you wouldn't be allowed to get 485 because you were out of status for more than 180 days. But if in 2009 you left and you came back 1 day later or 1 year later or 5 years later, we will forget about all that disqualification that happened in 2009. When you file the 485, we'll only look at what your status violations were beginning 2013 to the date you applied for 485, and we will then count the number of days of those violations, and if those violations were less than 180 days, we are going to give you your 485 right then. One thing that is important to understand, and I get asked this a lot, what do we have to do to invoke 245K? So do I have to do some special forms or special letters to the USCIS? The answer is nothing. USCIS is supposed to assess every case for 245K exemptions themselves. So you don't really have to do anything. I'm saying section 245K. Sorry. What I meant was press *5 if you have a question. Any follow-up question on this issue? *5. Okay. Let's go on to now this is where we have a lot of issues in the Trump NTA policy for denials. While the NTA policy has a bunch of sub-issues, and I have a recording on that which I did for our clients, but then I realized that a lot of people were asking the same questions. So we had asked our clients permission beforehand that we were going to post that discussion online, which we did 4 or 5 days ago. Our website will be down for, I think, 3 days while they move our servers to the cloud. Rackspace is working on that. I have a notification. I think it's this weekend. So even if you're not able to get into our website, you can go to our social media, YouTube, Facebook, Google Plus, and LinkedIn. You'll be able to see all the links to the discussion, the first NTA discussion. So I'll just summarize it very quickly. What the government is saying, which is relevant for you guys, there are other issues. There are issues regarding naturalization. There are issues regarding use of public benefits and NTAs, fraud and misrepresentation in NTAs, criminal convictions in NTAs. But I'm skipping all of that because most of you are concerned. If I file for an H-1B extension and the old H-1B has expired by the time my case is decided. Now remember, I can continue working for up to 240 days, but let's say on 241st day or even 300 days later, my case is declined. I can't work after 240 days, but I can continue to stay in the USA. What Trump's policy says, when we deny a case, we will also issue a notice to appear and start deportation proceedings. The problem with this process is that you then cannot leave the United States, because if you leave, then you are barred for coming back for 5 years. Once an NTA has been issued and filed, the proceedings have started, you can't leave USA. And for us to be able to get you voluntary departure or get the NTA quashed could take a few months, and even there you are not really allowed to work. And you're accruing unlawful presence if it's more than 180 days. So I suspect we could end up taking a lot of these cases to court simply because they are creating this very odd situation with 700,000. That's a lot of cases pending in immigration court, 700,000 backlog. They're adding all this extra backlog. How dumb is that? But they are trying to make life as difficult for us as they can. Hopefully they won't last long. In November, and everybody should work hard or at whatever level they legally can to make sure that Congress is won back by the Democrats. So this Trump nonsense can stop. But anyhow, that's what we are stuck with, and this is what we are going to deal with. So one of the things you can do is, if the RFE looks like it's really difficult to win, maybe leave USA while it is pending and wait outside. If the case gets approved, get a visa and come back. But there you have the problem that the visa stamping can take a long time as well. Of course, if you have an existing visa, you can return on that. But if you don't have an existing, for example, H-1B visa, and you have to apply for a new one, then be prepared for delays. And I would always prepare clients or employer to send the work to your home country, wherever you are, because it's perfectly legal for you to be working outside USA. Whether you are from China, Japan, India, Pakistan, it doesn't really matter. Wherever you are from, in your home country, you're authorized to work because you are a citizen of your home country. And you can work from there while you wait for the visa stamping. So one strategy is to leave early. The NTA doesn't say you can't file appeals and you can't file MTRs, but it doesn't really help. It doesn't stop the running of the time of unlawful presence. So it's a really bad policy created by Trump. And I think Steve Miller more than Trump, that little weasel, is responsible for a lot of these difficulties that immigrants are facing. Without any study, without knowing what the impact of these policies are, schools are suffering, enrollments are down, professors are not getting visas, doctors are having issues, hospitals are having issues, nurses are having problems, technology people are having trouble. But this is what they do. That's what happens when you have illiterate people, functionally illiterate people running the country. Nevertheless, that's my spiel for today. But going back to the NTA policy, that's the sum and total of what we know so far. Now, let's look at the specific issues. There are 3 or 4 different people that I have combined in this one discussion. Let me begin with Vijay Amin. I'm on USA on work visa for 11 plus years with the same company. I-140 is approved. Current H1 is valid till 2018. They've applied for an extension. If extension is denied after my current status expires, how many days do I have to leave USA? Well, that's the problem. Technically, this is another issue in the new regulations of January 17th. They are so garbled. It is just not good English or good law to even try to understand what they are trying to say. They say you have a 10-day period at the end of your H1B, but only if we give it to you. So it's just the regulation doesn't make sense. Then they say if you lose your job, you've got a 60-day grace period to apply through another employer. Of course, your I-94 should be valid for more than 60 days. If the I-94 is valid for 45 days, you've got a grace period of 45 days. Another very odd regulation, then it says we can shorten the time. So USCIS has the right to shorten the time, and there are no criteria described when they can shorten those 60 days. So there's a lot of uncertainty in this. Going back to your question, how many days we have to leave USA? I have no idea. What I would want you to do is leave as soon as possible, because if you have not been served with the NTA, and service is another very odd concept in the NTAs, it is enough service if they mail it to your last known address. But what if you haven't received it? I would want to make sure that you haven't received it. And if you are outside USA, you might still have to retain counsel. If the NTA arrives in your absence, somebody still has to go to the court and tell the court that, look, he left, and he left within the existing time frame, so that the NTA was not, let me rephrase that. He left before the NTA was served, and that's an important point. So you want to keep your boarding passes, anything that shows on which date you left, and the date you entered your home country through your boarding, through your entry stamp, etc. on your passport. Those will be good, important things to have. So how soon can you leave? There really is no grace period. And I don't know how quickly they will issue the NTA. If I know the government, what they're going to end up doing, this is my guess, and I hope I'm not giving anybody any ideas, that a denial and an NTA will come at the same time. So the moment they issue the denial, they'll attach an NTA to it, which really, really, really is bothersome. Personally, if I were the lawyer and they sent me an NTA, I would fight that NTA on the ground that I'm not authorized as a lawyer to accept the NTA. NTA can be served on the lawyers too, but I'm not authorized. My representation, this is my very simple argument. My representation is limited to my G28. My G28 says I'm only going to represent you in your H1B process, nothing beyond that. So why should I be served the NTA? And I think that's bad service in my mind. But those are legal issues. See, with this government, as with any, the smart thing to do is to avoid argument. It isn't about winning or losing argument. It is about avoiding argument. If I can avoid argument, I have won the case. If I get into an argument, I'm costing my client money, and I don't know which way it's going to end up. I could have the strongest case in the world. All it takes for Trump's progeny is, in their illiterate minds, but I must confess, there are plenty of good USCIS officers. In fact, I have dealt with some of them who are concerned, who are very conscientious, but they have to follow the policy enunciated from the top down. So you could end up with just somebody dismissing the most meritorious case, the best case in the world, with a stroke of a pen, and we end up fighting it. Okay, so I don't know what the time period at the end of your denial is. You should always deal with it, because this situation is still developing. They haven't really implemented it. Technically, it has been implemented on the date it was signed, but there is really no procedures in place right now. We'll figure it out over the next few days. We'll keep you informed. Stay tuned to our social media. I'm very active on Twitter. If I see something, I'll inform you. Twitter, Google+, Facebook and LinkedIn, all media, I keep them updated. as well as our own website, of course, immigration.com. If I already left the USA, this is the second question from Vijay. If we already left USA and notice came after that, I think you're okay. If you don't have actual or constructive notice, we can get that notice thrown out because it was served after you left the United States. And of course, your question is, can the lawyer represent our case? And definitely, we might end up doing that if we have to fight the NTA on legal grounds alone. Star 5, if you have a follow-up question so far, I'm going to go on to the other questions. There are other related questions in this. Star 5 if you want to know more about the NTA. Okay. So, from RJ111, is it possible to explain the rule below? And I did explain the rule. They've copied and pasted some information from somewhere. I don't know what that is. I think I've already covered this. So then they say, what is the best strategy? We should file the H-1B extension immediately when 6 months are left. Yes. And we have actually, in my first discussion on this issue, I said that file it premium processing as quickly as possible. And when H-1B is about to expire, you don't have to leave immediately, because even while you are awaiting decision, you're not out of status. They can't issue an NTA. Only upon denial they can issue an NTA. So you can basically time your departure with the response. If I don't know if I'm going to win this case, I can tell you guys, listen, you need to go outside USA. Let's have you wait outside USA. And once you have left, I'm actually going to do that for somebody who's on maternity leave, and she's in between projects. So the best thing for her is when I answer the RFE, before that, I'm going to have her leave. Once she leaves, she's going to inform me, and then I'll respond to the RFE stating that she's already left the United States because the project was terminated. So in those kind of cases, we can time it as long as the RFE is pending. You're not out of status and an NTA cannot be properly issued. Okay. And from Somashekhar, I have an H-1B expiring September, which is a couple of months from now. Applied for extension in April, got an RFE for employer-employee relationship. End client is not giving me letter. Can I provide documents like co-worker affidavit? I'm not going to get into all those details because there are so many ways you can handle this. I really cannot tell you without knowing what your case is. You should be discussing this with your lawyers who are handling this case. Should I withdraw my petition? Again, very difficult to answer. It depends upon the merits of your case, how strong it is, and your lawyers can tell you that. My I-94 is expiring September. If I file a new project with valid documentation, oh yes. So you are still in status till September. If you apply for another case, while this one is still, it has life, which is September, you're still working on the job good till September. If you apply for another case, it's not the same thing as a bridge petition where you're trying to cover a gap. Here, you applied for a second case within the life of the first one. So yeah, that's a good situation to be in. So once your case is filed before September, because of the second case also, first case is an extension, second case is a transfer, either one of them independently is sufficient to bestow legality of stay on you, what is called authorized period of stay. So you really don't have to go outside USA while this is pending. This is a very important question, Mr. Somashekhar. Will my green card processing stop if I leave? And the answer is no. However, you want to make sure that the employer has enough money to continue to establish ability to pay wages. So theoretically, excuse me, I need some water. Theoretically, at least, a green card can be processed completely in your absence. The only problem is there's something called ability to pay wages. Make sure you discuss that with your lawyers so that that money amount that is needed in the employer's tax returns or in their net current assets accommodates the fact that you're off the payroll. But the green card can go on, no question about that. Can I file 485 living outside USA? No, you cannot. For 485, you have to be in the United States and you have to be in legal status that permits such a filing. I am going to highly recommend, I'm not a litigious person by nature, but I'm going to highly recommend all of you guys to be prepared for litigations. Typically, these litigations cost in the neighborhood of $15,000 or so. I think it's a worthwhile investment, especially if employer is willing to share a lion's part of it. You can contribute a little bit, but those litigations may become the rule rather than the exception, because many of these cases you will have to fight them out, and especially if you have 3 or 4 cases of similar denials, they can all be filed as one. I wouldn't want to hypothetically state that because I don't know exactly. However, cases can be combined under certain circumstances, so that would make things easier for you. If I change my employer, get my petition approved with a new employer, then the dates become current. Can I join back my previous employer? And the answer is theoretically yes, again to be discussed with your lawyers. Theoretically yes, because as long as you have the intention to join, the employer had the intention to hire you back, and the job continued to exist, all 3 things remain, you have no problem rejoining the old employer. Okay? Star 5 on your phone if you have a follow-up question. I have another set of questions to cover after this one on the same issue. Star 5. I hope you guys can hear me. I'm getting some doubts. Let me just make sure.
The conference is now in conversation mode.
You guys can hear me, okay?
I can hear you.
Everyone? Hello?
Yeah.
I can hear you.
Okay, just
Yep,
want to
I
make
can hear
sure.
you.
Sure.
Okay, excellent.
The conference is now in presentation mode.
Okay, it's happened to me before one time that I talked and nobody could hear me. We got the recording done, but I couldn't do question answers. Okay, from Satish, current I-94 expires December 2018. Issued at the port of entry using advance parole. My current H-1B expires in Feb 19. So you've got an I-94 through advance parole, which is expiring in 2018. You've got an H-1B that expires in 2019. Planning to apply for EAD AP on August, 180 days. Yes, good. Hoping that we get the approval. You know that if you apply for EAD, you can actually, after the EAD is timely filed, the 485 EAD, not all EADs, but 485 EAD, you can apply 6 months ahead, and once you have filed it, you can continue working even if after its expiration. Is it 6 months or 180 days? One of the two. Maybe it's 180 days. So remember, 6 months and 180 days are not the same. Usually 6 months, or no, invariably 6 months is a little bit more than 180 days. So I think it's 180 days. So you can actually, you have a grace period to continue working. Do I receive an NTA if my H-1B is denied? No, you do not, because you have a 485 pending. So even if you receive it, it's not going to hurt you, because we can probably pick up the phone and call the USCIS, in this case actually ICE, and say, hey, this NTA has been mistakenly issued. Here is the evidence. You need to get this out of the way. Can I switch to the EAD if my H-1B is denied? Definitely. There's no doubt about that. Star 5 if you have a follow-up question on the NTA issues. I'm a little surprised. I thought you would have many more questions, because, oh yeah, okay, at least we have 2 now. Okay. So let's begin with, 3 now. Good. For a moment I thought you couldn't hear me. Then I thought maybe everybody was already aware of everything very quickly. So let's begin with area code, let's see, 312. Area code 312. Illinois. Go ahead, please.
Yeah, hi. Yeah, so I actually have a question of something that you just mentioned about, filing the EAD extension 180 days before, and then you can continue to work
Sure.
after the EAD expires for 180 days or 6 months.
I think it's 180 days.
But I think,
come to think it's 180 days. Yeah.
Okay. So what happens if it still doesn't come? After that, what happens?
You're allowed to stay in the USA as long as your 485 is pending. You just won't have work authorization.
Oh, okay. So, which is a problem, but I understand at least we can stay.
And the thing is, there are 3 levels. So think of it as, 2 levels actually. The ground floor is your 485. That level allows you to stay in the USA. On the second floor, you have advanced parole, which also gives you the permission to travel, and EAD, which additionally gives you permission to work. But if the top floor is taken out, you still have the ground floor, which allows you to stay in the US. Okay. Make sense?
Thank you. Yes, thank you.
You're welcome. Okay. Let's go on to area code. Give me a second to figure this out. This is area code 302, Delaware. Okay, yeah, Delaware, go ahead, please.
Rajiv, this is Satish. Regarding the EAD H1B question, right. Can I apply only EAD and travel using the advanced parole, and when I come back from the India, can I apply advanced parole separately? Can I do that?
Of course. I don't know of any law that requires you to file both EAD and advanced parole together. If you have advanced parole duration left and you got your EAD, you can always travel and you can come back and apply for an extension of the advanced parole. No problem at all.
So, but when advanced parole is pending, I'm not supposed to leave the country, right?
You're not supposed to travel when the advanced parole is pending.
Okay, thank you very much.
You're welcome. Good luck. Okay, and then now we have New York on the phone. New York, go ahead, please. New York, go ahead.
Hi, Rajiv. Rajiv, this is regarding NTA with the N400 application. Okay. So, in case if N400 is denied, my green card will be also cancelled, or it will continue, or how it is applicable to NTA, applicable to N400?
I'm actually dealing with a case recently, and I have advised them to, until a week ago I was going to do something else. Now I've advised them to do something else. See, in his case, what happened was he's got his green card many years ago. But the company that he was involved with had some issues. And there was some errors or some definite problematic errors on the 9089, the PERM application. So they denied his N400, saying that you have committed fraud. Actually, I don't think there's any element of fraud. He hasn't done anything wrong. While we were thinking about, I was going to fight this case right away, but then the NTA policy came out, and I decided to back off rather than invite an NTA, because remember, you have a green card. They can't just issue you an NTA and deport you. They have to take you all the way through immigration proceedings. So your NTA will say, come to the immigration court. The difference between you and an H1B holder or an L1 holder is this. Their H1, L1 has expired. Your green card is valid until it's taken away. You see my point? So the difference is you are in status. You have your green card. If they are trying to take your green card away, which could take 2, 3, 4 years, you still have your green card. Okay.
So in case, even though if they deny my N400, so they cannot do anything with my green card. Even though if they want to do it, it will take 4 years. But still I can continue staying. There should not be an issue.
Let me add another layer of understanding to that if I can. There's a difference between rescission and revocation. So green card, if it was obtained through 485, can be rescinded any times within 5 years. Okay, just with a notice of intent to revoke, they can revoke your green card. But once 5 years are over, they have to take you to immigration court through an NTA. And they have to take you through the proceedings, which can take many years. I don't know how many, but I'm saying maybe 2, 3, 4 years. So rest of your understanding is correct. I just wanted to add these 2 points.
Okay, so my green card for 5 years, I have like 2 more months. So I'm planning to apply within 90 days period.
No, don't do that. Don't do that.
N400.
Don't do that. Wait until 5 years are complete, then apply for N400.
Oh, great. Thank you. That makes sense. Okay.
Good luck.
So, okay. Thank you. Thank you.
Okay, it doesn't look like we have any more questions on this issue. Let's go on to the next. Again, I'm surprised. Maybe a lot of people have got a lot of information already. That's good. So let's go on to any other frequently asked questions on this page. No. Let's go to the next page. There are no frequently asked questions. So now we are going to go to the non-frequently asked questions, which I think are not asked all the time. Let's go and look at those questions now. So Rahul, are you on the phone? Press *5 if you're on the phone. I thought I had talked with you for some reason. This entire conversation seems so. Hi Rahulji, how are you?
No, I'm sorry. I'm not Rajiv. I was trying to get the option to ask you a question concerning the N500. You know, the last question you answered.
Oh, okay. Why don't you go ahead and I'll get together with Rahul in a few minutes. Go ahead and ask your question, sir.
Okay, so I was trying to figure out, so what is the N5? Is it N500 or N400? What is that exactly? I'm concerned. I'm really surprised. I'm surprised about this. I never heard about this before because I got my green card in 2014. I'm due for the citizen naturalization application next year.
Right. That N400
May.
That's the form you will file, N400, to apply for naturalization.
Okay.
So that's what an N400 is. So somebody applied for naturalization, got denied, and they have tried to dig up information from 11 years ago to try to deny his naturalization. I actually just finished a hearing a couple of weeks ago in which they tried the same thing. And I'm pretty sure we are going to win that case. But yeah, they are trying to go back as far in time as they can and try to deny your naturalization and even try to reopen your green cards in some cases.
Wow.
Yeah. So be careful. Talk with your lawyers. Make sure that they've examined your case. In some cases, we are advising people to hold on to their naturalization applications until there is a better administered law in place. This thing is just crazy.
Okay. Just one more question in line with this.
Sure.
If I wanted to retain you as my immigration attorney, later on, maybe not now, how does that work? Just call you separately after this? Of course,
you can just send us an email to help@immigration.com. Help@immigration.com. Okay. That's my personal email. But in many of these cases, I might advise you to get local lawyers if you want somebody to go to the interview with you, because I don't like to travel outside the area. I can send one of the other lawyers from the firm. But if you get somebody locally, it might be cheaper for you, and we can assist in the paperwork. So if there is any problem, we can step in. If your case is straightforward, having no lawyer or having a local lawyer is just as good.
Okay. But what if, I retain you and then at least we go through my paperwork and everything, and then you decide if I should go ahead and start filing for naturalization and then help me recommend a lawyer.
Oh, absolutely. I don't know if I can recommend a lawyer. I don't like many lawyers. There are some I like a lot, but most lawyers I don't like. It's not that they are bad people. It's just that our way of working is very different than other people's. It's not better or worse. It's just different. So I'm not sure I can recommend anybody to you, but I can certainly look at your case and recommend whether you should file N400 or not.
Okay. So I think I'm due for next year in May, or they say 90 days before the
No, don't do 90 days.
So
let full 5 years go by before you file.
Okay. Okay, sir. Okay.
All right.
Thank you. The other question I have is not related to this question. So
Okay,
you said there's no time for...
No, I don't have time for new
after,
questions.
so-
Well, we can deal with it next time, okay?
That's fine. Thank you very much.
Good
Appreciate
luck, sir. Bye-bye. Okay, yeah, I wish I had more time. Actually, it's becoming a little difficult even to find an hour because this administration is keeping us so busy with nonsense work. But we deal with it. We've gone through some tough times, both as immigrants as well as immigration lawyers. Well, we go on. So, Rahul, you're not here. I keep thinking that I have talked with you about this case because humanitarian paroles are certainly options. Tourist visa is an option. Remember, until tourist visa is denied, as I recall the rules, you can't even apply for humanitarian parole. Okay, so your name is familiar, and I think I have talked with you. And if you still have any questions, just write to me at help@immigration.com. I'm not going to discuss your case on an open line. Just write to me, and maybe we can talk. So Hema wants to know about her father going outside USA. Just remember one thing, guys. The rules for maintain. I should have actually posted this as a frequently asked questions. Never mind. I'm sure it'll come up again. For a green card holder to maintain their green card, their permanent home must be in the USA. There are people who've been maintaining green cards thinking that they can come once in a year and that's good enough. No. The law requires you to actually live here. Remember also that if you are gone for more than 6 months, your rights are reduced by a considerable amount, including the fact that because you're gone so long, eyebrows are raised that are you really living in the USA? The short and as brief as I can make it summary explanation for this 6-month rule is this. When a green card holder is coming back to the United States, to an unrelinquished residence in the USA, they are treated as a returning resident and their examination is different. But if they are gone for over 6 months, they can be actually, their rights are considerably diminished because they're not a returning resident. They are a resident seeking admission. And there's a little bit of a legal difference, but a vast difference in the number of rights you have available. So make it less than 6 months. And your father's home must be in the United States. Technically, if you leave USA even for 1 day, relinquishing your home, for example, you sell your goods, you sell everything, but 1 day later you say, oh, you know what, I want to go back and live in USA. Technically, your green card can be taken away. Because when you left USA with no date in mind when to return, and you had relinquished your domicile, your residence in the USA, your green card is gone. Okay? So make it less than 6 months. Do you have any follow-up questions? Hema, are you on the phone? *5 if you have a follow-up question. Next question is Mira. Mira, I didn't want to give you the understanding that I'm going to look for the law or research the law. I don't have time to do that, and our team is pretty busy too. So you're going to have to talk with your own lawyers and see if they can research it for you. I really don't have time. If I knew the answer off the top of my head, I would be happy to give it to you. We had a case like this a few years ago in which I did the research. In that case, what had happened was, and I'm trying to remember exactly what it was. It's a big company, but they were just starting out in India. It's an American company. They were just starting out in India. And they're a manufacturing business. And they sent a guy over who was a senior level manager who opened an office, signed up the leases, and started working. But he was working without having a company to report to in India. And eventually, 6 months, 7 months later, the company was incorporated. We were able to successfully claim the 6 months before the formation of the company and the 6 months after as part of the L1A package. So he was an Indian guy who was sent to India to set up an operation, and he used to be on H1B, but we were able to bring him back on an EB1C green card. So there was something, and I don't remember off the top of my head. Your lawyers are gonna have to research that. Next question is, okay, we already dealt with this. We've done all of this. Also about the Dropbox, what the rules are. Mr. Sundar, I don't know exactly what the rules are. I always look them up before I send somebody out. So the rules are fairly straightforward. If you look at them I'm assuming it's India, at the Indian US consulate in India, their site, it tells you exactly how the rules work. Okay. I don't have a follow-up answer for this, so I'm not going to invite a follow-up question. The answer is I don't know all the rules off the top of my head about the drop boxes and all. Just look at what the consular website says. So we've dealt with all this. And about selective services, as I recall, you can double check registration for selective services. This is one of the questions. I think registration is required for people who get their green card between 25 and 30. And while you're on a non-immigrant visa, the rules don't apply to you. And by the way, it happens sometimes you forget to, or you're not aware of the requirement of registering for selected services. You can actually justify it, and we've done a few cases like that, where a bona fide good faith mistake is forgiven by the government and it does not become a big deal. So unless you get your green card between the age of 25 and 30, I think, you can double check the ages, non-immigrant visa people are excused from registration. *5 if you have a follow-up question. *5. Okay, let's go to New York. Yeah, New York, go ahead, please.
Yes, Rajiv. I entered in H1B when I was 25 years.
So,
then I got the green card like 35 years.
Yeah, so you were
so
past
do I
that
need to
age.
register?
Yeah, you were past that age.
Oh, so I no need to register anything now.
Double check on the Selective Service website. I'm pretty sure it only is between 25 and 30, and I think their website clearly says non-immigrant visas are exempt.
Okay, exempted, then application I need to select no.
And the answer is, well, I can't help you fill the application, but the requirement is, see, I can't tell you what to fill in the application, but I can answer any legal questions you have.
Okay, sure. Okay. Thank you.
Good luck.
Thank you.
See, the problem is when you answer questions about filling out a form, there is actually a requirement at the end. Did anybody else help you fill this form? They should sign this form. So I really can't do that. I can't answer form specific questions. Madinu, my immigrant visa got approved as an unmarried adult child of a US citizen. Can I marry her now in my country? Not until you enter the US. Once you enter the US, after that you can go back and get married, and I don't see any cooling off period, and I don't see any issue of fraud here. It's perfectly legal for you to get married after you finish your green card by entering the USA. Okay? *5 if you have a follow-up question. Oh, one more question you had was, do I have to wait for the physical green card? Not really. Once you enter USA, your green card is finalized, but I would rather wait and get the green card so all the formalities are complete before I leave the United States, if I were you. Next question is, Hital says, upon entering US port of entry, spouse was stamped parole, admit until this date. Which date should I consider for refiling? You can apply 6 months, 180 days ahead of time. That's when you should apply. *5 if you have a follow-up question. Prasanna Nair says, currently work for employer A. I-94 expires September 2018. I've gotten approved I-140 from A, valid for over 6 months. Spouse is currently on F1 waiting for OPT EAD. I've got an offer from employer B, which I have accepted. In June 2018, employer A filed to extend my H1, no premium processing. Since adjudication might go past I-94 validity, which is September, A wants to upgrade my petition to premium and add H4 and H4 EAD to my existing application. Will upgrading A extension from regular to premium now allow my spouse's H4 and EAD to process into premium? The answer is not as a matter of right, but maybe as a matter of practice. There is no premium processing of H4s, and there is definitely no premium processing of EADs. So what happens as a matter of practice is when you file everything together, or when everything is pending, at least H1, H4, they do tend to premium together. EAD is erratic. I don't think there is any premium processing of EADs, but I have reports of people getting their EADs about the same time as the H4 approval. So as a matter of practice, maybe I don't have any definitive legal precedent to tell you that that's the way it's going to be. Two companies seeking for H1 extension, H4, H4 EAD impact my chances of working for employer B? I don't see why. And I think that your lawyer for employer B is correct. I don't see any problem with this at all. Star 5, if you have a follow-up question, star 5. Madhenu also wanted to know, is it necessary to send beneficiary's birth certificate when the I-130 is filed? If the instructions don't list that, you don't have to file it. But after September, my answer will change. If you file before September, I would say no issues. After September 11 actually, I would want you to file all the documents that you can think of. Star 5, you're not here, so I'm not going to star 5 you. Sarika 21, currently on F1 OPT, good till 2020 Feb. H1B petition through employer is approved, but change of status is denied. See, what happens is, when your H1B is approved but change of status is denied, so you continue in the old status. So of course you can continue working on your OPT until it is valid. But double check with the service in school. I've seen cases where even though they are not supposed to, they terminate your service as soon as the H1B is approved, not realizing that change of status has not been approved. So get in touch with your school right away. But you don't have to file any particular paperwork. There's no deadline of any kind. Just make sure that you get your school on board. Employer B can file your transfer. I don't see any problem with that. But I've had some debate with the USCIS where they say, well, you're really not exempt from the quota until you either get change of status or you get visa stamping. So to answer your question as to whether employer B can file, I think you can try, but I'm not sure which way the government is going to go on that. I'm certainly not aware of any written policy on this. Star 5, if there's a follow-up question. Deals for KR. My H1B, H4, H4E extension approved with my current employer A. Filed for change of employer petition for B. H1B is approved. H4 status for employer B is not known at this point of time. Does this cause any issue? Since H4 EAD is approved already, do I need to file for H4 EAD since I'm changing employer? Well, there's one confusion in your questions, KR. I'm not sure if you are talking about H1, H4 EAD, H4 for yourself, or H1 for yourself and H4, H4 EAD for your wife or husband. I'm assuming that it's the latter case, that you're talking about H1 for yourself and H4 and H4 EAD for your spouse. In that case, I don't see any problem. Even if you change employers, your spouse should not get affected by that. His or her EAD should be fine. I am not surprised that the H4 is pending. I'm surprised that the EAD is approved. That's a little odd, but it is what it is. So changing of employer does not cause any damage in H4 or H4 EAD. Star 5, if you have a follow-up question, star 5. Next question, Satish007, primary applicant on green card EB2 category. I need to travel to Canada on a business trip. Can my wife apply for EAD and AP renewal before me? I don't see any problem with that. Yes, she can. *5 if you have a follow-up question, Satish. Okay. Rajmani, I have an approved I-140 from company A, but with the wrong priority date. They are trying to get that corrected. No update. I switched to company B, started green card process. I don't agree with the company attorney who says I can only transfer whatever is listed on the previously approved I-140. I think if they provide documentation that the previous lawyer was trying to correct the situation, they can also agitate the same issue. I have an offer from company C and willing to sponsor immigration. Can I? And if so, what is the procedure? Yeah, you can. The priority date is automatically assigned to you. There is really no procedure needed. Government should be doing it themselves, and a letter or a phone call should correct the situation. And there's really no procedure for it except keeping in contact with the government and pushing them on this. You can also open an ombudsman's request. Also, the company C is 50% H-1B dependent. I don't think that should make a difference as long as the job is genuine. Do I have to wait 180 days? See, the thing is, as long as your I-140 through employer A was approved and stayed approved for 180 days and the period went past January 17, 2017, both your priority date and your right to extend H-1B through any employer is well protected. Nobody can take that away unless there is some kind of fraud in the I-140. Okay? So then waiting for company B for 180 days is completely unnecessary. *5 if you have a follow-up question. *5. Okay. So we have a question from Ohio. Ohio, go ahead, please.
Hi, Rajiv. This is Raj. This is just a follow-up for the same question. Thanks for attending. Thanks for taking the question and answering it. So I'm just trying to confirm what I understand what you said.
Right.
Is I don't have to wait for 180 days.
Yeah. Let's establish some facts. You have an I-140 approval from company A.
Yes.
That I-140 approval was still valid on January 1st, 2017. Or actually January 17th, 2017. Right?
Yes.
They didn't revoke it?
No.
And on that date, it had already been approved more than 180 days.
Yes.
Then your priority date as well as your right to extend your H-1 beyond 6 years is already solid. There's no need for you to wait for company B's I-140.
Okay, so now within last 2 days I got company A back to me and they're offering direction me to come back, but a different role than what it was on the I-140 previously approved. So is that the 180 days rule same if I go to company A, back to company A or company C or D?
No, there is no issue there. You can, if they still have a job open for you, I don't see any problem in going back.
Okay, so I can still continue the same green card application.
Yes, sir.
Without doing anything.
You can, but I do want you to discuss this in detail with your lawyers. There are some little technical issues that should be resolved, including the ability to pay wages, the continuity of the job, and I think they are relatively minor issues. Okay?
Okay, and does it matter? I mean, my title will be different this time if I go back, but it will be more likely the same thing.
That's not
same job profile.
Title is not something that bothers me. The job should be substantially similar, and that's a question to be decided between your lawyers and your managers. Because what is and what is not substantially similar is partly a legal determination and partly a technical determination.
Okay, thank you. And one just follow-up, last one. When you said for the priority date, the wrongly listed priority date, the company B should be doing it, the lawyer was wrong. But I mean, when you said the supporting documents, what kind of documents are we talking? Because when my represent
your priority date is established on the date of the perm filing. So a copy of the perm filing showing when it was filed. Then a copy of the efforts of the lawyer to correct the priority date. That should help.
Yeah, I did provide those too, but unfortunately, I mean, this is a big law firm. I don't know if I can name the law firm here or not,
Just
but
because it's
they
a
are
big
like
law firm doesn't mean they shouldn't be doing their job. They're representing you.
Yeah.
The priority date is your
Yes, I
property.
understand.
The priority date is your property. They can genuinely agitate that issue with the government.
Yeah, but they're really reluctant.
Can't do anything about that,
That's
but
kind of trouble.
I can only tell you what should be done, and that rest is up to them.
Okay.
Okay?
Okay, thank you. So if I email you at help at immigration, can I schedule a call for private?
Yeah, if you need a consultation, go ahead and send me an email. I'll set it up for you. Okay?
Thank you.
You're welcome.
Thanks.
Bye.
Bye.
Okay, guys. Yeah, I'm running out of time. Actually, I'm a little bit over time. Raj is done. Let's see if we have any more questions. I think I have 1 or 2 questions left. Oh, good. Only 2 more questions. Then we are done. Shiva says, I received approved H-1B in 2008. Good from October 2008 to September 2011, but I never used it. I didn't get it stamped. Can I reactivate this H-1B without subject to cap? And the answer is maybe it's worth a try, because if you look at their policy statements, the government has said, well, unless you, let me not call them policy statements. Actually, these are informal comments. They've said, well, if you never received a change of status and you never got a visa stamping done, we think you are still subject to the quota. But we have received cases as being exempt from the quota even in those circumstances. You can try. Star 5 if you have a follow-up question. Star 5. Okay. This is the last question for the day. Mikey says, I have a change of status request to change from H-1B to F-1, 3 months. Should I submit an I-539 bridge extension at least 30 days before the school starts, just like the B1, B2 visas? I don't know if you even can. I don't know how you can. So let's look at it again. You are going from H-1B to F-1. H-1B ended 2 months ago. No, I don't think you can do anything with this. I don't see any bridge that will help you overcome this issue. Talk with your International Students Office. Make sure that there are no service type impediments, because there's a problem that if you have filed for a change of status and your old status expired, I think 60 days before the start of the F1, then they will not give you change of status. There's some sort of rule which I don't remember off the top of my head. Your school will be able to tell you, and they are making a big issue of that. So if your previous status ends a certain number of days before your F1 is scheduled to begin, they will not give you change of status. You'll have to go for visa stamping. Star 5 if you have a follow-up question. Okay. Well, folks, as always, I really enjoy talking with all of you, and I think it's a privilege to be able to guide people with whatever information I have, and I look forward to speaking with you again in 2 weeks. I hope we can continue doing this, and this administration doesn't take away whatever little time I have on my hands. I would not want to stop doing this, and I intend to continue. So see you again in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in
The phone number and all are provided 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.